Hello everyone. Welcome to Code of Civil Procedure Lectures. I am Marjina Sultana, Assistant Professor from Indraprastha Law College, Greater Noida. In this video, we will discuss definition clause under Section 2 of Civil Procedure Code. Section 2 of the Code of Civil Procedure provides definition clause. It is the dictionary to the word used in the statute and gives the meaning of that word in the phrase related to the statute. So, what's the object of definition clause in a statute? The object of definition clause are to provide for proper interpretation of the enactment and to shorten the language of the enacting part. Presently, there are 20 definition clauses under Civil Procedure Code. Let's start discussing them. Clause 1 of the Section 2 of the Code provides code, which says that code includes rules. So it's very simple. We have already discussed in the previous lecture that the Code of Civil Procedure has two parts. One is section, first part is section, and the second part is schedules containing rules and orders. So the main body of the code is the sections, and the rules refers to matters of mere machinery which the High Court may adapt to local conditions. Thus, High Court are allowed to modify the rules as per circumstances. Clause 1 of Section 2 of the Code of Civil Procedure define decree. The section provides decree means the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. It shall be deemed to include the rejection of a plaint and the determination of any question within the section 144, but shall not include any adjudication from which an appeal lies as an appeal from an order or any order of dismissal from default. According to this definition, there are 5 essential elements of decree which I have highlighted here. They are formal expression, adjudication, conclusively, rights of the parties, and suit. I will discuss them in the next slide so we can understand the meaning of decree. Essential elements of a decree. Mandatory elements to be fulfilled to be a decree are: number 1, adjudication. It means judicial determination of the matter in dispute. Hence, if the decision is of administrative in nature, it cannot be considered as a decree. The adjudication must be about any or all of the matters in controversy in the suit. If there is no judicial determination of any matter in dispute, it is not a decree. For example, an order of dismissal of a suit in default for non-appearance of parties is not a decree, because they do not judicially deal with the matter in dispute. Next essential element of a decree is formal expression. There must be a formal expression of such adjudication. In simple terms, to be a decree, the court must formally express its decision in the manner provided by law. So a mere comment of the judge cannot be a decree. the decree follows the judgment and must be drawn up separately. Third element is suit. The adjudication must have been given in a suit. Suit means a civil proceeding instituted by a presentation of a plaint. So without a civil suit, there lies no decree. However, there are several specific provisions which enable certain applications to be treated as suits, such as proceedings under the Hindu Marriage Act, the Indian Succession Act, the Land Acquisition Act, etc. They are regarded as statutory suits, and the decision given thereunder are decrees. Fourth element of a decree is rights of the parties. The rights of the parties must be determined by the adjudication. Here, right means substantive rights and not merely procedural rights. Similarly, the parties to the rights in controversy should be the plaintiffs and the defendant. So, if an order is passed upon the application made by a third party who is a stranger to the suit, it is not a decree. It must have the decree must have determined the rights of the parties with regard to all or any of the matter in controversy in the suit. The last element of a decree is conclusive determination. The decision must be one which is complete and final as regards the court which passes it. This means that the court will not entertain any argument to change the decision. That is, as far as the court is concerned, the matter in issue stands resolved. For example, an interlocutory order which does not finally determine the rights of parties is not considered as a decree. On the other hand, out of several properties in issue in a suit, the court may make, make a conclusive determination about the ownership of a particular property. Such a conclusive determination would be a decree even though it does not dispose of the suit completely. Explanation to this clause provides that a decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of. It is final when, when such adjudication completely disposes of the suit. It may be partly preliminary and partly final. So, a decree is final if the suit is completely disposed of. If the suit is not completely disposed of, it is preliminary decree. In Bal Kasha versus Tulsibai, the court held that order must satisfy the requirements of section 2.2, that is, clause 2 of section 2, in order to become decree. Merely labeling it as a decree does not make it a decree. Under section 2 clause 3 of the Civil Procedure Code, any person in whose favor a decree or an order capable of execution has been passed, he or she is referred to as the decree holder. Accordingly, any decree passed in favor of a person who is not even a party to the suit shall also be considered as the decree holder under the code. In the case of Bajirao versus Kashirao, the court held that a decree holder is one whose name is inscribed on the decree and in whose favor such decree has been passed. That's it for this video lecture. We will discuss other definitions in the next lecture. Thank you for watching this video.